Good morning.
My lord, I would like to make a mention in part 2, item number 6.
Part two, item number?
Item number 6. Although the matter has been fixed for today, can the matter be listed in some other time, maybe after a week?
Wait, number 6, it is fixed for today.
Yes, my lord.
So why not today?
Due to personal difficulty.
Acha. Wait, let me take out the... Okay, yes. Today is what day? 23rd. Okay. Item number 6, yes, fixed
Yes,
for
my lord.
23rd.
Yes, my
Okay.
lord.
So, Mr. Lal Foxwala has some problem.
No, Ruben Larinsanga.
Okay. Learned Counsel, Miss, your name please?
LK mga Izwali.
LK Zwali, learned counsel for the appellant, submits that the conducting counsel has some personal difficulty and has prayed for some time. Prayer is allowed. List this matter after 2 weeks.
Oh, no problem.
List this
Yes,
matter after 2 weeks on a date to be fixed by the registry.
oblige.
May it please your lordship. Lordship, I beg to mention for listing of 2 bail application for tomorrow, your lordship, in orders.
Tomorrow I'm leaving for Gauhati, so it will be difficult. Why
Both
not
the matters will be
on Monday?
actually, my lord, both the matters will be coming up for the first time, so we have to only call the case diary if tomorrow.
Okay, fine.
Obliged, your lordship.
Okay. List it tomorrow.
May it please your lordship, may I seek indulgence in mentioning item number 8 of hearing list. The matter is handled by my senior, Mr. Bilaram Enga, who is unable to appear today due to personal difficulty. So,
You are for the respondent?
Yes, your lordship.
And yes, Mr. Samuel, you are there for the, you are the appellant. Okay, heard Miss?
Miss Larry Moderate.
Heard Mr. Samuel V. Changte, learned additional AG, right, for the state of Mizoram, appearing for the appellant. And Miss
Larry Moderate.
Lal Mauma Ralte, learned counsel for the respondent. Learned counsel for the respondent submits that the conducting counsel for the sole respondent has some personal difficulty and has prayed for some time. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Yes.
Or
Your
you want a
lordship.
date? It is your appeal. Okay.
Also, your lordship, I would like to make a mention in item number 26 of hearing list. So,
Daily list.
yes. So this may also be kindly taken up after 2 weeks if possible, your lordship.
When?
After 2 weeks, your lordship.
26.
Yes, yes, your lordship.
There is no 26 today.
Part 2, my
Part
lord.
2.
Yes.
26, yes. Criminal appeal. You can do it today. Okay, same parties. A learned counsel for the appellant makes a prayer for adjournment on the ground that the conducting counsel has some personal difficulty. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
Daily list, item number 1.
My lord,
Yes, you are for item number 1.
my lord, I'm for one. But I would like to mention, my lord, some similar matters in the hearing list: 9 to 18, 20 to 24, my lord.
Wait.
My lord, in
I'll just take out the hearing list. Yes, 9 to.
9 to 18,
These are all similar matters. Yes, power
my
grid.
lord, there are similar, but they involve a question of law. Factually, they are different, my lord, on different footing.
Acha,
So
this
I
is
would
this is in connection with item number 1.
It is, my lord, in
Acha.
connection with. So, my lord, we can take up item 1. When these matters come, I would be making a prayer to list them after 3 weeks for hearing. I would like to personally come and do the hearing, my lord. But because of the impeding weather condition, it was little difficult to
Acha. Okay,
travel, my lord.
so now you are mentioning item number 9 to
18
9 to 18, yes.
and 20 to 24.
Acha, 9 to 18 you write. A learned counsel appearing for the petitioner submits that there is personal difficulty in doing the matter today and has prayed for some time. Prayer is allowed.
My lord,
List it after 2 weeks.
3 weeks, my lord. My lord, if any affidavit is there, I may be granted time to file one affidavit also just with regards to the applicable law and the notifications.
Okay, there is a further submission that the appellant may be permitted to file the affidavit if required in the instant case. Prayers are allowed.
My lord,
List this matter after 3 weeks on a date to be fixed by the registry. Yes, you
My
have
lord,
to say something.
interim may continue.
Interim is there.
Yes, my
Interim
lord.
order passed earlier shall continue until the next returnable date.
My lord. My lord, independent order for all the matters, this may come, because
Okay.
they are not bunch matters. They are all
Independent
separate matters.
orders, huh? And what about the other matters you said? 20?
My lord, 20 to 24, same thing, my lord.
22 to 24?
220, 20
Or
to 24.
20 to 24 also same prayer, huh? Okay.
My lord, is separate independent orders, my lord.
Huh, separate independent orders.
And
Yes.
interim, there also may
Interim
continue.
shall continue until the next returnable date. What about item 1?
My lord. My lord, over here, my lord, I would...
Acha, you wanted to mention something, Mr. Counsel? You were saying something?
yes, my lord. Since my other friend has been praying time for hearing, I would like to object that, my lord.
Oh, you are objecting to these hearing matters?
Yes, my lord.
Acha, you write there that there is Mr. What were the matters here? 20?
My
No,
lord, 9 to 18
Uh-huh.
and 9 to 18,
Yes.
2020 to 24.
You write the learned counsel appearing for the respondent has objection to the adjournment of the matter and prays that the matter be taken up on a early date.
Yes, my lord.
So when can you?
Since my request is that if my other friend can come and do the physical hearing, otherwise, there
Is
Exactly,
it
my
that
lord.
because of the weather condition is unable to come? So agree on a date. If not 3 weeks, then 1 week.
will, 1
My
week,
lord,
my lord.
it will-
Since
My lord,
this has
it will
been
not
pending
be-
since
It will not be
2024.
possible. I do not want to give any commitment, my lord. After 3 weeks, outstation counsel.
There are
I will-
people
I would
coming,
like
my
to-
lord.
So
Yes,
I'll
my
fix
lord.
up a date. He'll have to come. Okay.
There are
he
people
should come,
coming.
Unless
My lord,
something.
after 15th of August, any date, my lord.
Okay, not after 3 weeks, you say, on 18th of August 2026.
Yes, my lord.
Okay?
My lord.
Oblige.
Yes, item number 1 is what?
My lord, brief background. This would also form a leg of my argument for the other matters. My lord, I am a PSU, public sector undertaking under Ministry of Power. We are the most premier agency and we are in the business of erecting, sustaining and creating transmission systems for the country. My lord, so my lord, one of the transmission lines that was coming up was in the name of Silchar to Melrihart.
This
Now,
has
this
come
is
up
a-
for the first time today.
It's a motion matter.
Achha. Oh yes, motion matter. Yes, okay. So
My
what
lord-
have you challenged here?
My lord, we have challenged the judgment. Annexure 1, page 66.
Achha, passed in a civil suit.
Civil suit, my lord. Now, my lord, the biggest impediment in this judgment would be, my lord, if my lord can only travel down to page number 82.
Yes.
Now, my lord, before I read into page 82, my lord, by virtue of the operation of section 164 of the Indian Electricity Act 2003, the central government, via a Gauhati notification, has bestowed the powers of a telegraph authority upon me. Now, those powers of the telegraph authority that have been bestowed upon me is only given to me of the part 3 of the Indian Telegraph Act.
Achha.
Now, my lord, under part 3 of the Indian Telegraph Act, when I am doing any creating a transmission system, my lord, we exercise powers under section 10B and 10D.
Achha, wait. You exercise power under
Section 10B and 10D.
10D.
10B, Bravo, and 10D, Delta.
Achha. Okay.
My lord, these powers of part 3 of the Indian Telegraph Act are given to us by virtue of a Gauhati notification issued under section 164 of the Indian Electricity Act.
Okay, this we will go into in details during the hearing
At
of
a
the
later
case.
stage. My lord, I'm just giving a brief gist over here.
Today,
So, my
let
lord,
me
what-
issue notice and what? You are praying for some interim.
My lord, interim on the stay, my lord. Because the Deputy Commissioner has issued a notice for payment of 1 crore 73 lakhs, my lord. However, my contention on
Payment
the
of what? As compensation?
compensation.
Acha, for to the owners of the land through which you have taken the lines.
My lord. Now, my lord, my main ground of argument is that the district judge is empowered to, if there is any dispute, my lord, what happens once I am the telegraph authority. The law empowers me to fixate the quantum of compensation. Now, when I have fixated a particular amount of the compensation aspect, my lord, if the party is aggrieved, only then can the party go to the district judge under section 16(3) of the Indian Telegraph Act, under which I am exercising my powers. Now, my lord, the district judge is empowered to take up the matter and decide the quantum on the basis of evidence that would be led. The district judge cannot delegate the power to any third authority, may it be the deputy commissioner also, to fixate the quantum of compensation.
Acha.
So that
So
is my main view.
here district collector was directed to fix the amount.
My lord. And my lord will see at page 82 of my petition, I'll only draw, my lord, to one small aspect over there.
Yes.
My lord, issue number 6, page 82. My lord, whether the plaintiffs are actually suffered crop damages due to construction of electrical tower and approach road by defendants or not, if so, to what extent? Till argument of the case, parties are not disputed on the compensation amount in respect of crop damages. My lord, when there is no dispute, there cannot be any question of enhancement. And that being aside,
But
my
they
lord,
have disputed the amount that you have paid. That is why they have filed the title suit.
my lord, they have filed the title suit, but they were seeking land compensation, my lord.
That you don't want because you are not acquiring any land, right?
Exactly, my lord. We are only having the right of a user, and we don't do land acquisition. Nor under the 1894 Act, even under 2013 Act, my lord, section 105, subsection 1, read with schedule 4, clearly exempts me from acquiring any land for transmission system. My lord, if we have to acquire land to draw transmission system, we'll be the biggest landowners.
Okay, let
So,
me
my
issue
lord-
notice and stay that order of the district judge.
My lord. And my lord, I'll place a judgment also, earlier other cases, similar order, my lord, in a sense to say.
Okay, well, I will. Right, here, Mr. Heard, Mr.
N. Khera, my lord, Nitin Khera.
N. Khera, Learned
N. Khera.
Counsel for, you are from?
My lord, Shillong.
Acha. Mr. Heard, Mr. N. Khera, Learned Counsel for the petitioner. This is an application?
227, my lord.
Yes. This is an application preferred under Article 227 of the Constitution of India, by which the petitioner has challenged the impugned judgment and order dated 10/11/2020,
My lord.
passed by the Additional District Judge, Aizawl District, Mizoram, in civil suit number 119 of 2017. The case of the petitioner is that the petitioner has set up, you have set up some 400 kV, right? The petitioner
My lord.
has set up 400 kV double circuit EHV transmission line from Silchar to Melriat, MELRIAT, and have also constructed and have also set up a high voltage electric towers, an approach road on the land of the petitioners, on the above the petitioner's land. While constructing, it is the further case of the petitioner that while constructing the said transmission line, they have paid compensation for the damage caused on the land, that is damage to the crops, trees and surface belonging to the respondents. It is stated that under section 10B of the Telegraph Act, what is this Telegraph Act? Of 10B of
Indian Telegraph Act 1885, my lord.
Indian Telegraph Act 1899. What did you say?
1885, my lord.
Wait 1 second. I cannot hear.
1885,
1885.
my lord.
The petitioner acquires the right of user over the land, and that they are not required to acquire the land. However, the respondent plaintiff, being aggrieved with the compensation awarded by the petitioner for the damages, filed an application under the Telegraph Act under section 16, filed an application under section 16 subsection 3 of the Telegraph Act, seeking adequate compensation, including adequate compensation to the effect that the market value of the land should be paid to them. Full stop. The additional district and session judge, Aizawl Judicial District, Aizawl, by order dated 10/11/2020, by hearing the counsels for all the parties, passed an order, issued directions that the district collector will assess the damaged area of only plaintiff number 1 and not with respect to other plaintiffs, and have also directed that the land of the plaintiffs is liable for acquisition.
And my lord, one of
Full
the
stop.
main ingredients at
yes.
page 80, my lord,
Acha, I'm
para
dictating.
21.
The learned district and session judge has also directed that the district collector has to assess the market value of the acquired land, including the solatium and interest. Full stop. And it was forwarded to defendant number 1 and 2, right? And the payment of the said amount was directed to be. Finalize the right. Assess the market value. Yes, and further directed that after the assessment of the market value, the same should be paid by defendant number 1 and 2. And that the said defendant number 1 and 2 should pay the plaintiff number 1 within a period of 4 months. The full stop. The petitioner, being aggrieved of the said directions, has filed the instant civil revision petition, mainly on the ground that, as stated above, they are not required to acquire the land, and that further it is prohibited under the Telegraph Act itself. The petitioner has also raised the ground that compensation has to be assessed by the district judge under section 16(3) of the Indian Telegraph Act, and that it cannot be delegated to any other authority, as has been done in the impugn order. That is all. Issue notice
My
to
lord,
the
my lord, the judgment may be stayed.
yes, issue notice to the respondents. Petitioner to take steps for service of notice upon the respondents. These are all landowners, right?
1 to 4.
No,
madam.
1 to 4.
Yes, madam.
Yes.
There are private
Notice-
landowners as well as state is there, my lord.
Acha. Notice upon respondent number 1 to 4 by speed post or by speed post with AD or by usual process. Mr. Samuel M.V. Changte appears for respondent number 5, 6 and 7.
Yes, my lord.
5, 6 and 7, and as such no formal notice is required to be served upon him. However, the extra copies to be served upon the learned government advocate by the petitioner within a period of 1 week from today. In the above facts and circumstances in the interim, more so due to the provision under section 16(3) of the Telegraph Act. Just give me that Indian Telegraph Act. Acha, 16(3) provides that it cannot be delegated, right?
My lord, I can read it. If any dispute
But
arises...
one second, let me take out this act. Yes, 16(3), yes. If any dispute arises.
Concerning the sufficiency of the compensation to be paid under section 10 clause D, it shall on an application for that purpose by either of the disputing parties to the district judge within whose jurisdiction the property is situated to be determined by him. And my lord, to give effect to this, let us read 16(5). Every determination of the dispute by a district judge under subsection 3 or subsection 4 shall be final. My lord, clearly it says that district judge will determine.
Acha, what about not acquiring, it's not required to acquire the lands? You have said
My
some
lord,
provision?
My lord, 10B.
10B.
B, bravo. May I?
Yes, central government shall not acquire.
The central government shall not acquire any right other than that of user only in the property under, over, along, across, in or upon which the telegraph authority places any telegraph line or post. And my lord, if my lord can also have the 2013 Lara Act, Land Act, I'll just make the point clear, the right to fair
2013
compensation.
what act?
The right to fair compensation and transparency,
yes,
Land
sir.
Acquisition Act. 2013. If my lord has it, section 105 gives the exemption, who would be exempted. Now, my lord, if I may
Acha,
just
sir,
read
give
it.
me that right to compensation, right to fair compensation and so on. Is it there? 105.
105, my lord. May I?
Yes.
My lord. Provision of this act not to apply in certain cases or to apply with certain modifications. Subject to subsection 3, the provisions of this act shall not apply to the enactments relating to land acquisition specified in 4th schedule. My lord, we can travel down to the 4th schedule. It would be right at the second last page of the legislation, my lord.
Yes.
My lord, entry number 12.
The
My lord,
Electricity Act.
My lord, I am functioning under the Electricity Act. Because of that, exercising powers under the Indian Telegraph.
More so, in more so, it is provided under section 16(3) of the Indian Telegraph Act 1885 that if there is any dispute regarding the quantum of compensation to be paid, the same shall be decided by the district judge, shall be determined by the district judge only. And also, it is provided under section 10B of the said act that the central government is not required to acquire any right over any property other than the user only, other than that of a user only, under, above, along, for placing any telegraph line or post. And also, due to the fact, and also due to the provision contained under section 105 of the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, which provides that the provision of the said act is not applicable to anything done under the Electricity Act 2003. This court deems it fit to stay the operation of the judgment and order dated 10/11/2020 till the next returnable date. List this matter after 3 weeks on a date to be fixed by the registry. Okay?
Item number 2.
My lord, I may be permitted to leave.
You are there?
I am permitted to leave, my lord.
Yes, yes.
Highly obliged.
Yes. Item number 2, yes. This is
May it
railways.
please your lordship, the conducting counsel, Mr. Kumar Medi, has requested me to appear on his behalf because of personal difficulty, and he has informed me that he will make personal appearance if the matter may be fixed on 6th August.
Today it has come up for motion only. You can do it.
Your lordship, he's not my senior. He has just requested me to appear on his behalf.
Acha, otherwise it will get deferred. Right. You want it to be taken up on some other date?
Yes, your lordship.
Or he will appear online?
To be fixed on other date.
Okay. As prayed for by the learned... You take this in the earlier file. As prayed for by the learned counsel appearing for the petitioner. List this matter for motion on
6th August.
6th of August 2026.
Obliged.
Item number 3.
Yes, criminal appeal.
Lordship, I'm appearing on behalf of the special PP again. And Lordship, notice upon both the respondent who were already completed. And
Acha.
as per the
Service
last,
is complete.
yes, Lordship. As per the last court order dated 13/7/2026, your Lordship finds it fit to wait for some more time to.
Acha, respond number 1 had expired, and in
Yes,
case
Lordship.
respond number 2, he had served
2 and
notice by hand and had filed an affidavit to effect and further. So today, what is the position? Today, respond number 1 has expired. 2, you have served it by Dusty.
Yes, Lordship.
3, it is not complete. Right.
Two was
Same is
already
complete on
my lord.
10/6. Okay.
Yes.
So let us appoint an equalate counsel
Yes, Lordship.
to defend respondent number 1, 2, and 3. 1 is not required.
Not required, my lord.
2 and 3.
Yes, Lordship.
Right. Okay. Heard Mr.
Ilan mga isang
Learned counsel for the appellant. It is seen. It is seen that that on the earlier occasion, this court had found that that respondent number 1 had expired. The service of notice upon respondent number 2 has been effected by the appellant by hand on 1/7/2026, and it is also found that service upon respondent number 3 is also complete on 10/6/2026. However, today when the matter is called up, there is no representation on behalf of any of the respondents. In view of the same, this court finds it fit to appoint an amicus curiae to defend. All the respondents can be defended by one amicus,
Yes, my lord.
to defend respondent number 2 and 3 in the instant proceedings. Accordingly, Mr. Biswajay Chakma appears before court regularly? No. And Lalram Dinthara? He appears. If he appears, I can appoint him. If he is regular, right? Mr. Lalram Dintara, no. Then Mr. Pautu, I had appointed him a few days before. C. Liang Lima is also not there.
Nothing.
Okay, Mr. Jordan Romingtonga. To appear accordingly, Mr. Jordan Romingtonga is appointed as the legal aid counsel to defend the cause of the said respondents. The appellant to serve the necessary papers is directed to serve the necessary papers upon the learned amicus curiae at the earliest. List this matter for further consideration. Trial records are here. Yes. List this matter for further consideration on after 3 weeks.
Yes, Lordship.
After 3 weeks on a date to be fixed by the registry.
Deeply obliged.
Item number 4.
This is contempt.
My lord, notice for all the respondents are completed.
Our service is complete.
Yes, my lord.
You are appearing for all.
Your Lordship, I appear on behalf of my senior CGC for respondent 6, 7, and 8.
CGC, this is contempt, personal.
Yes, Your Lordship.
So he is appearing for
Respondent 6, 7, and 8.
6, 7, and 10.
6, 7, and 8.
8.
Yes, Your
6,
Lordship.
7, and 8. Okay,
Yeah,
6,
Lordship.
7, 8 done. What about 1, 2, 3, 4, 5? They are all replaced.
My lord,
Secretary. What about 1? Okay, secretary to the revenue settlement. He is for the commanding officer, task force, Ministry of Defense, but others have to be, the service needs to be complete. Oh, it has returned from 1, 4, 5, 7, and 8. So all notices are delivered.
Your Lordship, I am instructed to pray for time to file the affidavit.
Heard Mr. Miss
Violet Mwani.
Ashwani, learned counsel for the petitioners, and also heard Mr.
Lian Ming Tanga.
Learned counsel for appearing for respondent number 6, 7, and 8. It is seen from the office note that service upon all the respondents are complete. But it is seen from the office note that notices upon the rest of the respondents are also complete. Mr. The learned counsel appearing for respondent number 6, 7, and 8 prays that he be given some time to file the affidavit in opposition. Mr. Zarang Sangpui, you are appearing for somebody.
Yes, my lord.
Ms. Zarang Sangpui appears for respondent number
6, 7, and 8.
6, 7, and 8 is there. Okay, led by Ms. Zarang Sangpui. Okay.
My lord, I was instructed to defend the case. However, I may be given some more time for filing my power.
He said that he will be filing affidavit.
No, not yet. The file down on me, Kashan.
You have not filed your power.
If I then.
Okay, you're right. You changed that order a little. Ms. Zarang Sangpui, learned counsel, appears for respondent number 6, 7, and 8, and she prays that she be given some time to file her power as well as the affidavit in opposition.
Yes, my lord.
Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry. You keep that line, that others are complete. Yes.
Item number 5.
Yes, criminal revision.
Yes, my lord, this is epoxo matter. Then I have filed an affidavit
Please, Your Worship. This matter also service is complete.
Respondent number 1.
Yes, Mr.
This is criminal petition.
Yes, Mr. But this is against the order of cognizance, where the learned trial court has taken cognizance without issuing a pre-cognizance notice under 223 as per the BNSS, which is a mandate.
Acha, precognition notice
Yes.
has to be served.
Yes, Mr.
That is the only irregularity.
Yes, Mr.
Okay, who is appearing for 1 and 2? 2, Venetiami can appear, or Zairang Sangpui?
Lordship, on behalf of my senior Miss Mary, since she's on legs, may this matter be passed over for the time being.
Okay, I will take it up after some time.
Because otherwise, they have to file a reply or something. We can put it for a date fix, and in the meantime, they can file a reply.
Whether reply is required.
They have to tell us. No, if they don't want to file it, even then, Lodge can then fix it for argument someday, and then we can argue.
Not today.
Lodge, otherwise, then we'll have to take a passover because my senior is also on legs. If it has to be argued, then Lodge will have to. Lodge, I will be also seeking a passover.
Okay, let it be passed over. We will see. Let both the councils come.
Please. Lodge, this will come at end of the list.
Yes. Or at 2 o'clock, whatever is suitable.
Lodge, then Lodge may fix it at 2 o'clock. Then I will come back.
No, if you can come back before that, if both the councils can come back well and good. And if you cannot, then at 2 o'clock or whatever.
Otherwise, Lodge, we can fix a date in this matter, and if they want to file in the meantime, they can file it. Otherwise, we can argue on that.
Let's see what the seniors
Please,
say.
I'm grateful.
Obliged, Your Lordship.
Item number 7.
My lord,
Complied?
no, my lord.
Oh, no. What about the counsel for the petitioner? Yes, Mr. Courtmaster.
Yes,
She is
my
wants to give.
instruction. My lord, the connected case pending before Supreme Court. The case was listed on 22/7/2026 yesterday.
Acha, against the order of this court,
Yes, my lord.
the violation of which has been challenged
next-
here.
Yes, the next date is 29/7.
There is delay, I think. Delay is condoned
Yes, already gone down.
by the Supreme Court. Okay, diary number so and so pending. Case number SLP 1 so and so.
Even the order is not yet uploaded.
Okay, we will wait for some time then.
Yes, my lord.
The petitioner counsel is also not there.
Not here.
Okay. Heard Ms. Jairang Sangpui, learned counsel for respond number
7.
7. The learned counsel has placed the instruction that the judgment, the violation of which has been raised in the instant contempt application, has been challenged before the Honorable Supreme Court, and the matter is pending before the said court. And as such, a prayer is made that this court may wait. Prayer is made that adjudication of the instant contempt application be taken after, may be taken on a later date. Prayer is allowed. List this matter after 1 month on a date to be fixed by the registry. Right? After 1 month. A Supreme Court which is registered as, you write, SLP within bracket C number 012758 of 2026, registered on 7th of April 2026. The said instruction placed by Ms. Jairang Sangpui is placed on record.
Item number 8.
Yes, what is this?
Please, Your Lordship, the conducting counsel, Ms. H. Somi, is on leg. I'm appearing on behalf. She's on legs in courtroom 1.
Okay, let it be passed over for some time. We'll take it up.
Lordship, my senior Mr. Caesaram Chana, who is the counsel for the respondent number 2, has some personal engagement. So, if the matter may be taken up any day on the first week of August.
Okay. On the prayer, on the on the prayer made by the learned counsels for the petitioner as well as respondent number 2. List this matter on 5th of August 2026. Ms. Linda M. Fombal is present for the state of Mizoram.
Item number 9.
Yes. There was some delay and it was condoned.
Yes, Your Lord, delay has been condoned, Your Lordship.
Today, let notice go.
My lord, it can be disposed of, my lord, if your lordship permits, because there's only a calculation error.
Is it?
Yes.
So, show me, I have not seen.
And regarding the deduction, it has to be 50% deduction instead of 1/4.
What did you say? I didn't get it. What?
They have proposed the calculation in the grounds of appeal. Senior grounds of appeal number.
I couldn't still get it. What did you say?
The grounds of appeal involve, there is an arithmetical error
That is
calculation.
it.
Yeah.
That
is,
means
that
it
is
can
one
be-
thing, and the other one is deduction towards personal and living expenses. The learned tribunal has made only 1/4 deduction, but as per the Sarla Verma and Pranay Sethi judgment, it has to be 50% is that deduction. So that's
Actually, the deduction was incorrect as provided under the Sarla Verma and all.
yes.
So,
Then- I
okay,
made-
that can be disposed of today. Matter.
Yes, my lord.
Yeah.
Okay.
And
The proposed calculation is at page number 9.
I thought he was speaking. Yes.
I made a proposed calculation at page number 9
Page number 9.
of
Okay.
my appeal.
What is there in page number 9? That is part of the order.
It starts from page number 8.
Page number 8. Okay. That is a ground.
Ground of appeal, yes.
Yes. You mean to say Roman 5?
Roman 5, Lordship.
Age of the deceased, that is okay, correct?
Yes.
Monthly income is also okay?
Yes.
10,000. So deceased was working as what? As a labor or what?
housemaid and cleaner.
Housemaid.
Yes, my lord.
And then annual income of the deceased? Okay, so this is okay. Percentage towards future prospect, 40%.
40%.
Okay. Income after deduction, half.
Yes, half.
So multiplier applicable is 16.
16, yes.
What is the incorrect, what is the wrong in it?
The incorrect calculation is, Lordship.
Mr. Courtmaster, it is hot. What happens? ACs are not on.
Page 20.
Hot. What feeling here? ACs are not on.
Ito, siyempre, mutila.
Yes. So show me the incorrectness in it.
Page number 16. Roman 16.
Roman 16? Where?
It starts from 15 award. Para number 35. The compensation amount payable to the claimant is calculated as under.
Where? Where are you reading?
Loss.
After the index, my lord, after the index, there is a certified copy of the judgment.
After what?
After the index.
The certified copy of the judgment. Roman 16.
Roman 6.
16.
Yes, 16 or 6.
Yes, 16. 1 6.
Yes.
Age of the income is the calculation.
Now, because of that, the calculation will come out to be wrong.
Yes.
So, calculation is 1,68,000 into 1 divided by 100 into 4.
Yes.
This should have been what? 1/4 percentage of income. So, you want half percentage of income.
So the total, the outcome has to be 13 lakhs, 44,000.
Oh, 26 lakh is wrong.
Yes, 26 lakhs is wrong.
So, what do you say, learned counsel for the what? You are the
I am for the
Claimant.
respondent claimant, my lord. Yes, the calculation is wrong, my lord, that I will fairly admit. However, my lord, with regard to funeral expense, loss of estate, and loss of consortium, that is the non-conventional heads. Pranay Sethi reported in 2017 in paragraph number 15, 9.8.
Do you have the judgment with you?
I have called from the library, my lord.
Mr.
The book.
Courtmaster, any some judgment he is talking of?
SCC का तो कौन था?
This is Pranay Sethi.
Pranay Sethi.
Now it's better. Okay. What does it say?
If your lordship may kindly turn to paragraph number 59.8. That is the second last paragraph of the judgment, my lord.
Wait. 59.8.
59.8.
Yes.
Reasonable figures on conventional heads, namely loss of estate, loss of consortium, and funeral expenses should be rupees 15,000, rupees 40,000, rupees 15,000 respectively. The aforesaid amount should be enhanced at the rate of 10% in every 3 years. So, Pranay Sethi is 2017 judgment. The date of accident is 14/7/2020. So it's after 3 years. And after the judgment, and the date of judgment is 28/11/2025.
So after every 3 years, 10,000 has to be 10%.
10%.
Should be enhanced, but then this is not enhanced in the
This is
instant
not
case.
enhanced, my lord.
Same amount is given.
Same amount is given.
For this, you want enhancement.
Yes, my lord. That's
So
all.
this calculation has to be properly done.
Yes, my lord.
So who will do the calculation now at this stage?
My lord, the calculation proposed by them in their grounds of appeal with regard to loss of dependency at page 9.
Loss of dependency.
Yes, at page 9A. This is the conventional.
There is no page 9A, only 9.
No, there is page 9 in their grounds of appeal, my lord. Loss of dependency, A.
At 16 multiplier.
Yes, this is actually correct, my lord. A is actually correct, but B is wrong.
He is saying that the deduction should be half the income.
Yes, my lord.
So in the award, it is done at the rate of 1/4. That was incorrect. From where are you saying this, Sarla Verma?
No, my lord. They have given a proposal for the calculation in their memo of appeal, page 9, my lord. This loss of dependency is actually the proposed calculation is actually as per Pranay Sethi and Sarla Verma. So A is correct, but with regard to B, there has to be an increase of 10%.
Okay.
That is all I am submitting, my lord. As per Pranay Sethi.
What do you say on this, Mr. Counsel? 10%, there has to be an increase in every 3 years.
I have no objection in this regard, Lordship, because it is as per the Pranay Sethi judgment.
Okay.
But that is only in respect of conventional hedge.
B. With regard to B.
Conventional compensation only. Yes. Okay. Heard, Mr. Your name, please. Learned Counsel for the United Insurance, the Learned Standing Counsel.
Yes.
Learned Standing Counsel for United India Insurance Company Limited, Aizawl branch. And Mr.
Zoram Chana.
Zoram Chana, Learned Counsel for Respondent number 1. And what about the others?
The others, I don't think they are required, my lord, because they are the driver and owner, and they are only challenging the quantum of the compensation.
Okay. So and so. By this application? Filed under Section 173 of the Motor Vehicles Act 1988, the appellant has challenged the impugned judgment and order dated 28/11/2025, passed by the learned member, presiding officer, MS City Aizawl, in MSCT case number 33 of 2020. The petitioner has a limited ground of challenge, and according to him, the calculation done by the learned court of MSCT, calculation done by the learned court of member cum presiding officer MSCT Aizol in its award by the said judgment and order impugned in the instant proceeding. According to him, the deduction, according to him, the income after deduction should be at the rate of 1.5, right?
Half.
1.5 of the said income.
Half 50%.
50%.
That is 50% of the income. But the learned court had calculated the same as 1/4 of the income. And as such, he submits that the calculation made by the learned court, to the extent, what is the calculation made? It is not given in the award. The calculation is this 3 made by the court as 1,68,000, right? 1,68,000
Yes.
into 1 divided by 100 into 4,
Yes.
which comes to 1,61,280 is incorrect according to the learned counsel. Full stop. It is submitted that, where is that Sarla Verma providing for half?
Sarla Verma and Pranay Sethi, Your Lordship, as per the Pranay Sethi judgment, which is at
Pranay Sethi also provides
yes,
that.
Pranay Sethi also is.
Paragraph?
Paragraph 39.
The learned counsel submits that deduction of 50% of the income should be deduction of the income
Towards personal and living expenses.
Towards personal and
Living expenses.
living expenses should be 50% of the income.
Yes.
And by calculating the same, it comes to rupees 84,000 and not 1 lakh something, right?
Yes.
And not 1,61,280
Yes.
as calculated by the learned court. To substantiate the argument, he has placed reliance on the decision of the apex court passed in National Insurance Company Limited versus Pranay Sethi, reported in 2017-16 SCC 680.
And Sarla Verma.
Yes. Now, where is that? Paragraph 39.
Sarla Verma. Yes.
No, it's the Pranay Sethi about the deduction of income towards living expenses, where it is said that it should be half.
Para 31.
In case of bachelor,
Yes.
31.
Yes.
Wherein it was held that where the deceased was self-employed and or was a person of fixed salary without provision for annual increment, the court in Sarla Verma reported in 2009-6 XCC 121, the court in its earlier decision, in Sarla Verma versus DTC, reported in so-and-so, has held that it should be a rule that 50% of actual salary could be added if the deceased had a permanent job and if the age of the deceased is between 40 to 50 years. This is the ruling, right?
Yes.
50%. As such, he submits that the calculation done by the court was on a mistaken belief and not as per the law laid down. Full stop. Para. On the other hand, the learned counsel for respondent number 1 had pointed out that the calculation made in the award by the learned court with regard to the conventional compensation was incorrect in view of the findings given by the Supreme Court in the same case, that is National Insurance Company Limited versus Pranay Sethi, Supra, wherein it was held that with regard to conventional heads, although loss of estate, loss of consortium and funeral expenses should be should be calculated at rupees 15,000, rupees 40,000 and rupees 15,000 respectively. But it is also held by the Supreme Court that the aforesaid amounts should be enhanced at the rate of 10% in every 3 years. Full stop. He submits that the case of Pranay Sethi was delivered by the Supreme Court on 31st of October 2017, right?
Yes, madam.
31st of October 2017. And as such, he submits that after 3 years, that is in 2020, the said amount should have been increased by 10%. And thereafter, again, on conclusion of another 3 years, that is in 2023, right?
Yes, madam.
So it will be increased by 30%.
Yes, madam. No.
10% every
20%. 20%.
10% in every 3 years.
That is, this is six years. So that means 20%.
Acha. And this judgment was delivered which date?
This was delivered on 28/11/2025.
Okay, so 20%.
20%.
And what did I say? क्या बोला? No, another 3 years, that is in 2023, another 10% should be, and 2023, another 10%, no, 2023, the same should be enhanced at another 10%. And since the judgment in the instant case has been delivered in the year 2025, as such, the learned counsel submits that the said amount towards conventional compensation should be increased by 20%.
Yes, madam.
And the same was not done by the learned court of MSCT, ISO. Full stop. He as such submits. So that will come to what amount? Page number 9 shows it correctly.
Yes. Page number 9 shows it correctly with regard to A, but with regard to B, funeral expense would be instead of rupees 15,000, It would
Wrong.
be,
Wait. Yes, B. You are saying it is wrong.
yes.
But B will be how much?
Funeral expense will be rupees 18,000.
Okay, funeral expenses will be rupees 80,000, 20% more.
Yes, 20% more.
And loss of estate
will be the same, 18,000.
will be
18,000.
18.
Yes.
And then consortium
And loss of consortium would be 48,000.
48,000. Now, as a learned counsel submits that as far as the funeral expenses is concerned,
And the total would be, my lord,
funeral expense is concerned, the amount should be 80,000. How can be 18,000? 18? Right, 18,000.
18,000. It is.
And with regard to loss of estate, the amount should be 18,000.
No. Oh, yes, madam.
And towards loss of consortium, the amount should be 48,000
Yes, my lord.
by applying the law laid down by the Honorable Supreme Court. And the total would come to
Would come to
84. It comes to 2, 3, 4, 5, 6, 7, 8. So it's 84,000.
Yes, sir.
Yes, madam.
Right.
Yes, correct.
So the total comes to an amount of rupees 84,000
84,000. Yes, my lord.
towards conventional compensation.
Yes. And by adding A and B, it would come to,
As such, full stop. By making the necessary calculation, that is recalculating the amount payable under the column deduction of income as well as the conventional compensation, the total amount comes to and then the total amount, that is rupees 13,044 lakhs, 13,44,000. 13,44,000 plus 84,000, right?
yes, my lord.
And the total would come to how much?
14,28,000.
Wait,
1,428,000.
comes to 8.
14,28,000.
Yes, and the total comes to 14,28,000.
Yes, madam.
Full stop. Hence, the appellant, it is appellant, right? Or petitioner? Appellant. Hence, the appellant is directed to deposit an amount of rupees 14,28,000 along with interest at the rate of 7% only. At the rate of 7% per annum from the date of filing of the claim petition dated 1/12/2020. Under section 166 of the Motor Vehicles Act 1988. Full stop.
My lord, the amount will be deposited before the registry or the MSCT, if an observation may be given. Before the MSCT or the registry of
Registry of this court.
Yes, my lord.
Yes. The appellant is directed, and that amount you'll have to recover from the driver or something.
No.
The owner of the vehicle.
The owner.
Yes.
Before that, after paying the compensation amount, the appellant is at the liberty to recover the said amount from the owner of the vehicle if it is permissible under the law.
Owner oblique driver.
Huh?
That's it. Owner oblique driver.
Owner or the driver.
Owner. I think it has to be owner.
Is it?
Yes.
But the vehicle was not insured or what? It was insured.
No, it does not. It does not
Liability.
possess permit. Yes.
There is no valid permit. There was some expired permit for plywood in Mizoram, so they raised that ground. My lord, let them deposit it a period of 1 month. It has been pending since 2020, my lord. It has been pending since 2020, this claim. So let them deposit it in a period of 1 month, my lord.
Okay. But what about taking it back, recovering it from the driver or the owner?
They will
It
have
is
to-
otherwise provided in the award.
that they will have to do, my lord. No, I mean the deposit of the award.
Okay. Is at liberty to recover the said amount from the owner driver of the offending vehicle.
One prayer, Lordship.
Huh?
Regarding that statutory deposit, we have 25, we have deposited 25,000 for as statutory deposit. So
That you want to take it back?
yes, please allow me to.
Statutory deposit by when you file the appeal.
Yes,
That will be adjusted.
No, they can take it.
That can be adjusted or you have to take it back. Full stop. Further, the amount deposited as statutory deposit by the appellant while filing the appeal before this court can be adjusted towards
But
payment.
let them take it back because it will create a confusion in the calculation.
Is permitted to be taken back by the appellant. The amount of rupees full stop. The amount of rupees 14 lakhs 28,000 is directed to be paid by the appellant before the registry of this court, from where the payment will be made to the claimant, right?
Yes, my lord. With interest, my lord. That part with interest, the amount. The amount with interest, my lord.
Oh yes, with interest, as stated above, should be paid. So and so.
Lordship,
in the
period of 1
cases,
month.
Lordship,
yes.
Lordship, even in the statutory deposit also, along with interest, if any, may be added.
That I'm not aware. Whether you have to again take it back, or who will pay you the interest? The sport? No, only 25,000. Whatever you have.
25, there may have some interest since it has been deposited in the bank, so it may raise some confusion.
As per law, you just say as per law. The petition is disposed of.
Yes, my lord.
The appeal is disposed of.
Thank you, Lordship.
Item number 10.
Take this.
Your Lordship,
Yes.
I'm appearing on behalf of my senior, Mr. Bilaram Enga, for the Council of Respondent number 1. So, Your Lordship, if I may kindly be granted another 3 weeks' time to file our affidavit in opposition.
You had already taken time before.
Yes, Lordship. If I make one submission,
For
Lordship.
respondent number 1. Right.
Yes, Your Lordship.
You had taken time on the how many occasions?
Last court date is 30/4/2026.
Yes, 34/2026. Okay. Okay. Learn counsel
Yes,
for the
Lordship,
witness.
if I make one submission, it's the case is pending for quite some time, so if last chance may be given, Lordship.
Last opportunity.
Yes,
okay.
Lordship.
Heard, Miss?
Pare.
Learned counsel for the petitioner. For the petitioner. And Miss?
Very moderately.
Learned counsel appearing for respondent number 1 and Miss Venishami, learned state counsel appearing for respondent number
3 to 7.
3 to 7. A learned counsel appearing for respondent number 1 submits that although she had taken time before to file the affidavit in opposition in the instant case, but due to some genuine reasons she could not file, and as such has prayed for further time to file the affidavit in opposition. The prayer of the learned counsel for respondent number 2 is allowed. However, it is directed that respondent number 2 should file the affidavit on the next date
Your
fixed.
Lordship, 1.
Or respondent number
respondent
2, respondent number 1 should file the said affidavit within by the next date fixed without fail. List this matter again on
After 3 weeks, if
list
possible, Your
this matter
Lordship.
on 19th of August.
Yes, Lordship.
Much obliged.
Deeply obliged.
Item number 11.
What is this IA? Delay.
Yes, Lordship. There is 406 days delay, madam.
So many days delay?
And Lordship, I'm appearing on behalf of my senior, the special PP, Your Worship. So if this matter can finally be taken up on first week of August.
Yes, Mr. Potter, you are the amicus.
No, my lord, it's
Not amicus, regular.
personal capacity.
So DPP is not there, he wants time, so what do you say? You have filed your objection?
I have filed my objections, my lord. But still, my lord, though the leading counsel is not here, my lord, I would like to raise one issue.
But then he is not there
Yes, let it be on the
on the
on another
The
day.
learned counsel appearing for the appellant submits that the learned learned PP,
Special PP.
a learned special PP for the petitioner, for the appellant, has personal difficulty and could not appear before the court today and has prayed for some time. Prayer is allowed. List this matter. On 4th of August, 5th of August 2026, Mr. Party, learned counsel, appears for the sole respondent and has also filed the objection to the said condonation application. List is accordingly on 5th of August.
Deeply obliged.
Item number 12.
Yes, Mr. Victor.
May I please your lordship? My lord, in this case, it's a regular second appeal. TCR has arrived, the trial court reports as well as the report of the first appellate court. So
What report? The trial court records
report
have
of the report of the trial court reports as well as the first appellate court
has been received.
Yes, my lord.
Yes.
So paper book would be required, my lord, in this case.
What is required?
Paper book.
Paper book is required.
Yes, my lord.
Acha, you are appearing for respondent?
Respondent, yeah. Sole respondent.
Sole respondent. Heard Mr. Victor L. Ralte, learned counsel for the appellant, and Mr.
Remruat Fella.
Remruat Fella as also heard Mr. So-and-so appearing for the sole respondent. It is seen from the office note that the records of both the first appellate court as well as the civil court has been received. Full stop. The learned counsels for the parties makes a prayer that the paper book be prepared. Prayer is allowed. The registry is directed to prepare the paper book and list this matter for hearing after 3 weeks.
After preparation of the paper book.
After preparation of the paper. Okay.
Yes, your lordship.
There's an IA or something?
IA is for stay, my lord.
For stay?
Yes, your lordship.
For
The appeal is
It is
already
stayed.
admitted. Status quo was cited.
So, okay, let it be continued.
Yes, your
Right.
lordship.
In the IA, you
My
write-
lord, I have a strong objection regarding the prayer.
No, have you filed your interim
Yes,
vacation application?
yesterday we submit before the registry. I
A
think
vacation application, but it's not in the records. Let it be taken up on a later date then. Okay. In the IA, you write, this is an application for stay of the judgment and order dated 29/1/2026, passed in RFA number 19 of 2025. Mr. So-and-so learned counsel for the sole respondent submits that he has filed an application for vacation of the said stay order. However, the same is not found in the records as the said vacation application has been filed only a day before. A status quo order has been already passed on 29/6/2026 and the same be continued until the next returnable date. List this matter on?
Along with the main case.
Yes, list this.
My lord, if we wait paper book, I think it will be taking too long. So after 2 weeks or 1 week.
So, paper book का वो लिखा ना, there you put a full stop there. To prepare the paper book. Registry is directed to prepare the paper book. Right, full stop. List this matter on 12th of August 2026. Here
My
also
lord.
in the I also list this matter on 12th of.
If I may, my lord, instead of 12, my lord, since usually we take up the bench matter on
Oh,
Wednesday.
yes.
Any
So
other
it
day.
will be on 14th of August.
Let it be, yes.
Let it be on 14th of August.
Be obliged.
Item number 13.
So this is a contempt.
This is the contempt state for praying for extension of time for compliance of the honorable court order. Your Lordship, in the last court date, an adverse order was passed.
In the IA, you mean?
In the IA, yes.
Huh.
It's 29/6/2026.
Acha, on the last occasion, it is said that you have to place the exact order, exact steps that you have
Yes, yes.
taken.
Your Lordship, in the last court date also, I have the confidential, etc. in my hand, but with due respect, Your Lordship, with due respect to this honorable court, I was not heard, I was not given a proper chance to explain myself. So I have furnished a copy to the court officer, Your Lordship, on the steps that we have taken.
Acha, what is this contempt about?
I will route through Your Lordship with the brief facts of the case. The petitioners in the writ petition are an association, a group of members who are working as teachers under Sarva Shiksha Abhiyan, which is a centrally sponsored scheme. This centrally sponsored scheme, the financial formation at the initial stage in the 9th-year plan was 85% to 15% ratio, and thereafter it's 50-50 from 50-50 from the central and the state. That is, this scheme was in partnership with the state and the central under the RTE Act, and from 2018, it was handed over to the state.
Oh, entire to the state?
Yes, entirely to the state.
So no 50-50?
No 50-50.
Okay.
Not now.
So center will sponsor
Yes.
the Sarva Shiksha.
Now, initially there was Sarva Shiksha Abhiyan and RMSA, but now it has subsumed in the one group, which is renamed as Samagra Shiksha Abhiyan.
Samagra Shiksha, yes.
So mainly the scheme is concentrating on the compulsory education at the stage of elementary for the children up to the age of 6 to 14 years. So in view of the scheme, certain numbers of employees were recruited, and the petitioners association are the members in Mizoram who are recruited under the scheme on various occasions starting from 2022. Now they have approached this the learned single bench, this honorable court, for advancement of their career, and upon due consideration, the this honorable court was pleased to make a direction to the state respondents. First is to consider the regularization of the members of the petitioners association. Yes, and
regularization of their services as teachers.
Yes, of the SSA teachers. Second is that to create a cadre post.
Career progression. MSAP.
Cadre post for the
cadre post.
For yes, for of such force for the SSA. And the third is, or in doing so, to formulate a scheme for the terms and conditions of such regularization. Now, that was in 17th March 2026, and that is the year of the election. Change in the ministry.
So the order was in
2023.
Okay. March 2023, the
March
orders were-
17, 2023. Yes. So it was decided, initially it was decided that we will file an appeal. The state will file an appeal against the order, because we have, from the initial stage, we have a grievance with the respects to the constitutional scheme of employment, etc. That we have grievance. But then and end of 2024 came, 2023 came, and there was code of conduct was called for, and then election was
Code
held.
of conduct in 23.
2023, because the state election, legislative
State election was there at that time?
Yes, yes. At that
Mizoram
time.
state election.
Mizoram state election. Code of conduct was commenced, and then there was change in the hands of the ministries, and it was decided that we will not go for an appeal. And then came 2024. In 2024, in compliance with the order of this honorable court, the government has formulated a CSS regularization scheme of 2024.
Scheme was formulated.
Scheme is formulated for the CSS employees in Mizoram. So that would, the state has diligently followed up the compliance order, because we have diligently believed that, we have a firm belief that since they are the employees of the CSS under the Mizoram, and there are numbers of other CSS employees who would have the same, who will be in the similarly situated place. Then CSS...
So you have formulated a scheme.
We have formulated a scheme. And then we have formulated the scheme, and then there are more than 6,000 CSS employees here in Mizoram. Now, no doubt, there are around 1,200 members of the Petitioners Association, but they are covered under that scheme. And process of regularization is ongoing, but then with the volume of the works that the service records and the scrutinization that is that it requires, so we have approached this honorable court by filing this IA for compliance.
When was the contempt filed?
Contempt was filed
only?
in 2023. And
After
this
1 year?
IA, and yes, and this after 6 months. In 2023 itself, contempt was, it's contempt 17 of 2023, and the government, in taking action, believing that we have taken firm action, we have progressed, we have processed the files, and then knowing that we are not going to even though we have said that we have substantially complied with the order of this honorable court, but then in true spirit we cannot finalize. That is why we have approached this honorable court by filing the IA, praying for 2 years time extension. So that means we have already taken about 2 years time. We have already taken about 2 years time, almost 3 years, 3 years before filing the IA. But the complexity that I will explain, and Your Lordship, when this case was yes.
Acha, show me the order first of this court.
In the
IA, the order is there.
IA, yes.
In this IA, Mr. Victor, you have filed a written objection also?
Yes,
Your Lordship. To what it so, my lord, on the last occasion, this matter was already heard. And the submission, whatever they made, is a blanket submission in respect of all the CSS employees under the state.
But then
That is why this court had already held that unless they furnish specific steps taken in respect of the present petitioners, my lord, this IA cannot be allowed. Now they fail to place the steps.
What are the specific steps? I'll see.
Your Lordship, if I may take Your Lordship kind attention to page number 33.
28 is the order or what?
33, annexure 1
33
of the IA.
33 is a part of the order?
Yes, it's the order.
The order starts from page
33.
28.
33 in my...
Okay. Where is
And the
the
relevant
direction?
portion, the direction, Your Lordship, is...
is at page 70.
70, paragraph number 23. That upon due consideration of the case in its entirety, I find the grievance expressed by the petitioner association to be legitimate and has merit. Accordingly, the state respondents are directed to consider regularizing the services of the members of the petitioner association against the existing vacant posts.
Of government teachers in the appropriate grade.
Yes. Keeping in mind the experience and training undergone by the members of the petitioner association and the object and mandate of the RTE Act, and in the alternative, that is the alternative, to sanction new posts as SSA teachers by creating such cadre, it would be open for the state to frame a scheme providing for further terms and conditions on which such regularization shall be done. So 2 tiers, that is to consider the services of the
Regularization.
members of the association against the existing post, or to create a new cadre post. So what we are intending to do is, by framing the 2024 scheme, we are trying to consider their regularization in the service of the members against the existing post of the government teachers. So that is what we are trying to do.
So you have started the scheme.
Yes,
And,
it's in operation now.
Of providing for further terms and conditions
Yes,
on which regularization will be done.
yes,
So that exercise should have been completed by 6 months. But then you took so long.
yes, we took
You
so
had
long.
started
Correct.
the scheme when?
2024. We have, if I may take your lordship kind attention to
The bunch that you have given? Or what?
no. I have annexed the scheme here, your lordship. It's
Have you annexed a scheme with this IA?
yes, your lordship. It's page number 134. 134, annexure 10.
134.
134.
134 is not there in the IA.
In the IA, it's there, your lordship.
There is no page 134 here. 91.
It's
No.
IA 28 of 2026.
Not the same IA. From where you have just placed the judgment?
The IA that is listed for today is IA number 28 of 2026.
Where is that scheme?
Page number 134, annexure 10.
134 is not there. Annexure 10 will be some different page. Wait. Annexure 6, 7, 9 is a gadget notification. Yes, 9 is the gadget notification of the scheme. This is the one, page 79.
Your lordship, I'm very sorry. My file was
79 is the scheme.
yes.
Yes. The scheme dated 18th of June 24.
Yes, scheme.
Yes, I've got it.
Sorry, your lordship. My pagination, they have.
Doesn't matter. I've got the
They
scheme.
have changed.
The scheme is called Government of Mizoram Regularization of Centrally Sponsored Scheme.
Scheme 2024.
This is actually after more than 1 year.
Yes, yes.
More 1 year, 3 months.
However, as I'm not denying that it has taken time, but formulating a scheme and taking decision and passing the scheme, it requires time. And your lordship, this was notified in the 18 June 2024. And after this notification, steps was taken. Your lordship, I'll just straightly refer to the instructions that I have placed before your lordship. Because I cannot use my copy anymore. They have changed the whole pagination.
The bunch of papers that you have given.
Yes, your lordship.
So it starts with May 2026, 28th of May.
Yes, yes. Action taken. This was a letter written in my name to me by the Undersecretary School Education Department. So yes, the scheme is there for CSS employees as a whole in general. But then now coming to the compliance of this honorable court in WPC 173 of 2018, I'm going to refer this because this concerns only the employees of SSA. Now, your lordship, I have, as I have submitted before, I have had a copy of the confidential file also before, but then now I do not have it, but I can always produce it again if so required. Your lordship, I'll start from furthermore. Furthermore, in the first line. Furthermore, I am directed to state that confidential
furthermore, yes.
documents, namely report on restructuring of Samagra Shiksha Abhiyan, and second, report first phase dated 30th September on regularization of centrally sponsored scheme by the study team constituted under School Education Department to scrutinize matters relating to Government of Mizoram regularization of CSS employee scheme as mentioned in serial number 9 and 10 respectively have been placed in separate confidential file. The same may be returned to Department after perusal. So it was returned after, it was not perused by this honorable court at all. And your lordship,
start from the beginning after the judgment was passed. What steps? I mean, 18.6 is the scheme. Right.
18.6 is the scheme. Before the scheme was passed, there were several correspondence and decisions that was there, which I have already annexed in the IA. If need be, I will route through your lordship on the steps.
So the first step that you have taken after the judgment is the formulation of the scheme.
Yes, the substantial steps is the formulation
Until
of the
formulation of the scheme, you must have taken various steps.
Yes. So
of course, that takes time. Even if we consider that 1 year period is sufficient, is good, is required for forming a scheme. But after that, 24, 25.
I will explain, your lordship. Page number 2, your lordship. Action taken, serial number 1. In compliance with the judgment and order, so we have formulated the scheme.
Yes.
It's annexed as annexure 1. And in line with the above scheme formulated with the government, a meeting to discuss representation of Samagra Shiksha Mizoram employees was held, and thus a meeting decided to form study team under Department for implementation of the government scheme for regularization of the current employees. So that is.
But in the judgment, you are supposed to do your exercises with regard to the petitioners. Now here,
yes, exactly, your lordship. That is how I'm going to explain. We have made the scheme, CSS scheme of 2022. Now, coming to paragraph number 2, that is the first initial steps that we have taken in terms of the compliance of this honorable court order, because current employees, this is under the Samagra Shiksha employees. This concerned with the Samagra Shiksha employees.
And the scheme covers also other employees.
Other employees, but we are not concerned. I am concerned while dealing this, only I am taking out only the steps taken with regards to the Samagra Shiksha employees. So that is why I have stated, they have stated, in line of the above scheme formulated by the government, a meeting to discuss representation of Samagra Shiksha Mizoram employees. So it does not say CSS employees as a whole. So that is how we have taken steps.
And a meeting decided to form a study team.
Yes, a study team.
Study team to
study team under the department. Yes, to of how we are going to apply the scheme into the
teachers.
Yes, to the teachers. Hence, that is in June. And in July, a study team under School Education Department was formed to scrutinize the prospective of so-and-so in-depth examination and application to all employees in every district present under the Samagra Shiksha Mizoram.
And in the writ petitioners were from different districts, right?
Yes, they are from different districts, and then the list of members are, if I'm not mistaken, about 1,200. Maybe more than that.
1,200 something
Yes.
petitioners.
Yes, 1,200 something. List of members of association.
Okay.
And they are posted in different parts of the state.
Okay, then after that, the governor of
And
Mizoram issued an order.
the governor, in the interest of the government, issued an order wherein study team and the school education department implementation was designated to additionally make recommendations for restructuring for administrative setup of Samagra Shiksha within the functional structures of the school education. So they are trying to find out the feasibility. And in the next page, Your Lordship, whatever I have submitted before this court, I have the annexed there.
Okay, these are the steps that you have taken.
Yes, the governor additionally appointed so and so as member of the study team, and in serial number 10, an office memorandum regarding checklist for submissions of proposals connecting to government of Mizoram regularization of census scheme to avoid delay, and which contain the following details. That is, the number of posts proposed to be
So
filled.
what extension do you want? For how much? How many months?
2 years. 2 years we have a sort.
2 years?
Yes, if 2 years is too...
2 years is too long. You have to, the requirement is that you frame a scheme.
Yes.
Giving further requirements, further norms or whatever.
Correct, Your
So
Lordship.
you, 2 years you will not take.
Yes, I understand, Your
And
Lordship.
that is
It
an
might not be
alternative.
practical, but Your Lordship, if I may be given at least 10 minutes of chance, I will try to sum up my submission, because I want to place these whole facts before this honorable court. And Your Lordship, the first things that we require is the number of posts proposed to be filled by regularization as per the scheme. And that is what the study team have to consider. Copy of centrally sponsored scheme guidelines, copy of advertisement to determine whether proper recruitment procedures were followed by recruiting agency at the time of initial engagement, copy of constitutional approve of DPC, copy of DPC meeting minutes, copy of initial engagement, list of eligible candidates as provided, report recommendation of performance evaluation committee. This is very important. Report recommendation of performance evaluation committee intersect seniority list of eligible CSS employees under the department. Document supporting educational and qualifications and relevant recruitment rules, list of provisional employees, roster, etc. And there was change in the hands of the government officials. So time and again, the study team was also restructured.
But then see, you have gone to the initial appointment. This will not be required.
No, Your Lordship, that is as a whole, but that is just for scrutinization. This has already been dealt with in the merits of the case. Admittedly, in the WBC 128 of 2019. But then they have to consider all the aspects.
Going to the initial appointment and all will be too late in a day. You see, if you find them, their induction was wrong, then you will not regularize. That is not the purport of the judgment.
I understand, Your Lordship, but then that is the checklist that we have made first of all. And after that, Your Lordship, in 2025, April, after individually studying all so they have collected all the documents from the various parts of the districts and the states and villages. After individually studying all the important documents of the employees present in the state and district projects and schools under Samagra Shiksha Mizoram, which includes deputation of teachers in the state project offices and not in their original place of posting, had formulated proper methodology, including its findings, ultimately make recorded recommendations for restructuring of Samagra Shiksha to the secretary for their kind consideration.
But then this exercise was not as per the judgment. Judgment said you form a scheme or in alternative, and then you giving some other modes. But then you appoint a study team who will go into each and every aspect. Those were not.
We are not saying that. We are not saying that these are just the checklists that are in the service reports that is required. But then it does not say that this. So that is why I haven't come to your inquiry. We have to gather all their services And then it was the study team who have to consider that. And the study, whether the study team have considered it correctly or not, that will come into a later phase. Now, the phase is that they have to collect the service records, first of all, and the list of eligible candidates, the list of seniority, etc. So that is why we have to collect all the materials that that concerns with the members of associations. So, Your Lordship, after that, and anyway, rightly or wrongly, whatever steps that we have taken, is that 28/4/2025, so they have made a recommendation. And after that, in 3/12/2025, proposal for regularization of special teachers for children with special needs under careful consideration department for kind examination. This first phase is the teachers of SSA.
For special
yes,
children.
yes, for special teachers with special needs. Now it's almost, it's in the verge of completion. So we have taken steps. We have, in fact, grouped them into different phases. And the first phase is almost complete as we speak. And Your Lordship, coming to page number 6, Your Lordship.
Page number 6. What about 5?
DP and I are now for regularization. DP and AR have after careful examination of the proposal and regarding regularization, had requested to furnish the documents, etc. And on 22/1, sorry, Your Lordship. So I'm going to this. See,
In fact,
a copy
you have-
of CSS guidelines.
In
what
fact,
they
you
require.
have extended the gamut to such an extent.
Yes, Your Lordship, what happened is that you were confused with the initial appointment, etc. But then here, for the recruitment, Your Lordship, in page number 10, what we have, what you can be seen is that DPNAR is the department concerned. This is they require the CCS guidelines, constitution approved by DPC, and roster of special teachers, report recommendations of performance evaluation, final intersectionalities, and proposed pay. So they are not asking for all that. So this is only in line with compliance of this honorable court order. So this is just a requirement, a simple requirement. The DPC meeting, rosters of teachers, record recommendation of performance evaluation committee, final intersectionality, proposed pay. So, in Your Lordship, my Lord was a little bit confused with the requirement of the study team, but then this is the outcome of what is required by the concerned department, DPNAR. Now, the department, after considering this is this is in the month of January 2026. Department, after considering the fact that special teachers are Group B employees, decided that examination of different documents, thus all pertaining proposals of documents are sent to directorate, etc. And this all concerns with the, now they have taken steps, and in 13, Directorate of School Education has sent instructions to district education officers a sample format for submission of performance evaluation report for guidance. Thus, the report is actively pursued by this DEO and expected to be complete within this month. So, after that, what happened was that, if I may take Your Lordship kind attention, page, in the subsequent page, you will see that they are grouped into different phases. The first phase is almost complete as we speak, which is which we can submit before this honorable court. So it is not a case that we do not take steps on their behalf. It is submitted. It is the general belief that is made before this honorable court that we are taking the steps as a CSS employees in general. But then, as I have just shown, Your Lordship, we have specifically taken steps with respect to the petitioners association. It is not a case that we slept over.
No, not a case that you have slept over, but you are enlarging the scope to such an extent you'll not be able to reach to any final stage. And you have started seeing their appointment letters, their initial inductions.
No, but
their-
that is not the requirement anymore in the DPC that we have shown you, Your Lordship. It's the performance evaluation report.
Okay, that is given in the order. You have to see the experience and the seniority. But then, okay, but what do you say, Mr. Victor? But then the time that you have prayed for is too long. If you can finish it within another 6 months, okay. But 2 years is too long a period. Victor, what do you say? What
Please,
are
Your
your
Lordship, my
objections?
lord, as Your
Of course,
Lordship
Mr.
notice-
Victor, what happens is forming a scheme is a difficult task.
No, my lord. I'll make it clear, my lord. The judgment was 17/3/2023. Direction to consider regularization of the writ petitioners within the period of 6 months. And in the alternative, they can also frame a scheme. That is the direction. And as submitted by my learned friend, there was a scheme in the year 2024. But the cabinet meeting had held that that scheme does not cover the writ petitioners. So we have brought that to the notice of this honorable court in the contempt proceeding. And only thereafter,
It
my
does
lord,
not cover the teachers.
that is the stand taken by the respondent authorities. So we have brought that to the notice of this honorable court in the contempt proceeding. And as directed by this honorable court, my lord, the school education director had filed an affidavit on 21st August 2024 by specifically stating that they have some misconception with the writ petitioners. So
They're stating what?
they have some misconception.
Ah.
So on 21/8/2024, the director has stated that the writ petitioners shall also be brought under the scheme of the 2024.
How writ petitioners will be covered?
Meaning thereby, yes, Your Lordship, meaning thereby until 21st August 2024, they have not taken any steps at all towards consideration of the case of the petitioners. And in this present case, my lord, the respondent authorities have not filed any appeal or review. So the judgment has now attained its finality. And my lord,
Now,
I have-
that she said they have not filed appeal. Why you had not filed appeal, Miss Mary? What did you say? I forgot.
It was at initial stage. It was decided that appeal should be filed, but then there was change in the hands of the ministries, and there was a huge campaign for not filing the appeal. So it was decided that.
Okay, this had attained finality. Okay, Mr. Victor. Then
so ultimately it has now attained its finality. So my lord, thereafter, my lord, it's a judgment of 2023. Now 2024, only in the month of August, they have said that, okay, they shall also be brought under the scheme of 2024. So my lord, in the year 2024-25, now we're in the year 2026, I have examined and go through all the documents which they have annexed. There are no any specific documents which are specifically for these writ petitioners in compliance with the judgment order. That is the reason, my lord, this court on 29/6/2026 had specifically held by this honorable court that such blanket submission cannot be accepted. But now, my lord, what happened on the other hand was that during the year 2025, the state respondents have their own agenda. They have recruited as many as 1,024 casual teachers. Now, in this present stage, my lord, they have sought for permission to fill up 1,215 posts. And they have taken steps for filling up of that post, my lord. I have enclosed the documents. Now they have obtained approval from the DP and AR to fill up 312 posts of primary school and middle school teachers on open advertisement, while neglecting and totally ignoring the standing direction of this honorable court. They have their own agenda, my lord. And moreover, my lord, this IA they have filed on 10th February 2026. And after this, my lord, they're just awaiting for the outcome of the order to be passed, which they have expected in this IA. They're just sitting folding hands on their office, my lord. What they have most prioritized is the recruitment which they are undertaking, my lord.
casual.
Regular teachers as well, my lord. During the year 2025, they have recruited as many as 1,024. Now they were proposing to fill up 1,215, which they have obtained approval for 312. And they have been taking active steps in this regard, my lord.
Advertisement issued.
Not yet, my lord. I have enclosed the approval for filling up obtained from the finance and the DPNAR.
For filling up 300 something posts.
312. Now, whatever statements they have made, my lord, those were in respect of the entire CSS employees or the SSA, which may be 6,000 plus. But the present petitioners were only 1,356 as on the date of filing the contempt petition. But due to these reasons, my lord, some have now unfortunately expired and some have now attained the age of superannuation without getting any benefits from the judgment, my lord. So, my lord, without close scrutiny of the monitoring of the steps taken by the respondents, my lord, if the IA was abruptly or simply allowed by giving such period, my lord, they will not take any steps. I can say that in view of the past, the experience that we had faced. And they have referred to some study team, they have referred to some office memorandum regarding making of checklist or evaluation team. But that does not pertain to the present petitioners. That is in respect of the entire CSS employees under the state government or as well as the school education department.
That will be inclusive of you. I mean, why? You are also an SSS employee.
That is true, my lord, but at the same time, where is the particular steps taken in respect of the present petitioners?
They are taking as a whole, everyone together.
Exactly, my lord. And my lord, this
And you
contempt,
said that initially it didn't cover you, the petitioners.
that is what they have stated. But even in the absence of the scheme, upon their interpreting the direction of this honorable court, they were directed
Where
to,
is that statement of the director? You said that this scheme will cover the
in
petitioners.
the contempt case, my lord, affidavit dated 22/8. In the contempt case, affidavit dated 22/8/2024.
22/8,
Yes, your lordship.
2024. Where is the affidavit? 22/8, right?
Yes, your lordship.
Yes. So what is the paragraph? By respondent number 5.
Yes, your lordship. Paragraph number 3 on the following page number 3. The para starts from, it may be stated, it may be necessary to state. Third paragraph of para 3. It may be necessary to state, have you got it, your lordship?
But in 2024, this case was not sub judice. When was the contempt case? Achha, they are talking of the contempt case. Yes, Mr. Victor, it is said in business necessary that petitioners have stated before the court that as per minutes of the meeting of the cabinet, 24 scheme was not to be applied to those employees who have approached the court and whose cases are sub judice. So by that time, you have filed your contempt.
Already, your lordship.
The same has also been
It was filed on September 2023.
There were no specific mention of the scheme. However, it is annual, however, it is discontinued, expenses, So, Miss Mary, this 2024 scheme was actually not in pursuance to the judgment.
Your Lordship,
In the minutes of the cabinet meeting, it is written that it will not be applicable.
that
it
was
shows-
some misconception, Your Lordship. At the time, DPNR AR was framing the 2024 scheme, while this the case was considered. So the DAP and AR have suggested that this will cover their case. So it is not specifically in the initial stage, the inception of the schemes, formulation of the scheme, was not only for the purpose of the petitioners association, but then
Sorry,
it
that
was squarely
was-
covered. Yes.
Yes, squarely covers, but not in pursuance to the judgment. Nothing specific was done in pursuance to the judgment.
Not the specific steps that we have taken is what I have presented before your lordship.
That I have seen.
And
Okay,
Your
but
Lordship,
as
it
far
was-
as the
yes.
contempt is concerned, this will, as far as the I is concerned, I can dispose it of, but not the contempt. Contempt, we will hear it later, right? What do you say, Mr. Victor?
Yes, Your Lordship.
I don't think so. This is maintainable, Miss Mary. Okay, this is not maintainable. You have not done anything specific to the petitioners, but the judgments speaks of specific to the petitioners. You had started the scheme for all the people employed under the scheme, under the schools, but not specifically to them, right? And there is a cabinet meeting also, cabinet note also, that this will not apply to the petitioners since the case was pending. So, what about the main observation apart from that in the alternative? To regularize them, right?
Yes, Your
To
Lordship.
regularize you.
To regularize them in the
by
existing vacant
adding
post
cadre.
or create new cadre, and in doing
This
so
has
may
not been
forward
done. This has not been
This
done.
has not
Only
been
scheme.
done. Their eligibility or otherwise is not in dispute now. This court had already held that they are eligible. So direction was made to regularize them in the existing vacant post. That has not been done in a single way.
Okay. Heard Miss Miss Mary L. Kyangte, learned additional advocate general.
Your Lordship, government advocate.
Learned government advocate for the state of Mizoram, and Mr. Victor L. Ralte, learned counsel for the respondents. For all the respondents?
Yes, Your Lordship.
For all the respondents. By this application, filed under section 151 of the CPC for extension of time in complying with the directions given in the judgment and order dated 17/3/2023. No, you write this is an application filed under section 151 CPC, praying for extension of time. Praying for extension of time in complying with the directions given in the judgment and order dated 17/3/2023, passed in writ petition number 128 of 2019. The learned counsel for the applicant, Miss Mary L. Kyangte, had placed the steps taken towards compliance of the directions contained in the said judgment dated 17/3/2023. What is the date? Dated 17/3/2023. By the said judgment, this court, after a lengthy discussion of the issue at hand, had directed the state respondents to consider regularizing the services of the members of the petitioner association against the existing vacant post of government teachers in the appropriate grade, keeping in mind the experiences and the training undergone by the members of the petitioner association, and also to keep in mind the object and mandate of Right to Education Act, full stop. This court, by the said order, had also directed in the alternative to sanction new posts as SSA teachers by creating such cadre. It was also directed that the state government, in order to give effect to the directions, may frame a scheme providing for further terms and conditions on which such regularization shall be done. this court had directed that the said exercise should be initiated and completed within a period of 6 months from the date of receipt of the certified copy of the said order. Full stop para. The Petitioner Association, being aggrieved by non-compliance of the said order, had filed the contempt application, being contempt case number 17 of 2023. Which is pending disposal before this court. During the pendency of the said contempt application, the instant IA interlocutory application has been filed by the state respondents for extension of time for compliance, for extension of time to comply with the said judgment and order dated 17/3/2023 as stated above. Full stop. Para. The learned counsel for the state respondents had stated that as ordered by this court in the said order dated 17/3/2023, that in alternative, the state respondents can frame a scheme for regularizing the services of the petitioner. The state government had formulated the scheme, namely the government of namely Government of Mizoram regularization of centrally sponsored scheme within bracket CSS employees scheme 2024, and that the scheme was formulated. The scheme was formulated on 18th of June 2024, and the same provided that the scheme will come into force from the date of publication in the official gazette, and the said scheme was published in the official gazette on 18/6/2024, which means that the scheme came into effect from and on 18/6/2024. She thereafter stated that subsequently on 27/6/2024, a meeting was held to discuss the representation of Samagra Shiksha Mizoram employees and in the said meeting, it was decided that a study team should be constituted for implementation of the said scheme. She also stated that the study team was constituted to look into the aspect of regularization of current employees. She thereafter stated that a study team was constituted to look into the aspect of regularization of the employees working under the centrally sponsored scheme. and that the same includes all the employees in every district working under the Samagra Siksha Mizoram. She then stated that by a notification on 28/8/2024, by an order, by an order dated 28/8/2024, the Governor of Mizoram had ordered that the said study team would also look into the aspect of making recommendations for restructuring the administrative setup of Samagra Siksha Mizoram. Full stop. And the Governor of Mizoram had also appointed a deputy director in the Directorate of SCERT as a member of the study team to look into the said aspects, including the examination in respect of regularization of CSS employees. Thereafter, a notification was issued on 21/10/2024 by which the number of posts proposed to be filled up by regularization as per the scheme were directed to be identified, as well as various other exercises were directed to be undertaken. Thereafter, she submits that on 28/4/2025, after 28/4/2025, after individually scrutinizing all the documents in respect of the employees under the Samagra Siksha Mizoram, which includes other exercises also, the study team submitted a report to the Secretary and Honorable Minister, School Education Department, for their kind consideration. And the said report the said report included various exercises to be undertaken in phase wise and also school wise. In the said report, the proposal for regularization of special teachers for children with special needs was also endorsed to the DPA and AR department. And that thereafter on 23/12/2025, DPAR is Departmental Promotion and Appraisal,
Personal and Administrative Reforms.
Department of Personal and Administrative Reforms, after carefully examining the proposal given by the study team had further asked for documents in respect of various teachers working under the CSS. CSS is what? Centrally sponsored scheme. Under the centrally sponsored scheme. And thereafter, she further submits that thereafter various exercises were undertaken. Full stop. Oh no, full stop. She further, therefore, she submits that the state government was carefully looking into the aspect of regularization of the teachers working under the Samagra Shiksha Abhijan, including the petitioners, and for their including the petitioners. Full stop. Para. Mr. Victor L. Ralte, learned counsel for the petitioners, however, submits that the said the directions given by this court, as mentioned herein above, were to be completed within a period of 6 months from the date of the receipt of the order. But the state governments had not done anything pursuant to the said order, and after more than a year had framed a scheme which was meant for benefit of the employees under the centrally sponsored scheme, and the same was not specific to the petitioners for whom the order was passed. He further submits that when the scheme was formulated, there was a minute of the cabinet. Where was it? What was the affidavit? What date you said?
Your Lordship, that can be referred back from the order of the order in the contempt case, 25/6/2024.
I have taken it out, but where did I keep? That was dated what you said?
Lordship, may I kindly see order dated 25/6/2024 of contempt case. Order.
25/6/2024.
Yes, Your Lordship.
I have taken it out and I'm not getting it. 2024, right?
2024, 25/6 order dated in the order sheet.
5/6/2024. 22/8.
That is the affidavit, my lord. That is the affidavit of the director. Now-
No, you had shown from somewhere.
Yes. Already, Your Lordship.
What page? Oh, yes.
Page
I've
number
got
3.
it. What did you say? Yes, wait. Came to be known as so-and-so and came into force on so-and-so. No, he further states that in the affidavit filed by the Director of School Education on 22/8/2024 in the contempt proceedings, it was stated that although the petitioners have stated before the court that as per minutes of the meeting of the cabinet, the 24 scheme was not to be applied to those employees who had approached the court.
Lordship, if I may, in that regard,
But okay, I'm stating that this was a misconception.
Okay.
Don't worry, not finished. Okay. Comma, the same is applicable to the petitioners, and that there was a misconception that it will not be applicable. But the fact remains, according to the learned counsel for the petitioners, that the scheme was not strictly applicable to them, but to all the employees working under the centrally sponsored scheme, which was not the direction of this court in order dated 17/3/2023. He further submits that the specific direction by this court was to consider regularization of the services of the members of the Petitioners Association against the existing vacant post in the appropriate grade by taking into account the experiences and the training undergone by the members, by the teachers. But the said regularization was not done, and neither the existing vacant posts were identified by the respondents concerned. He further submits that the additional direction that was given was only in the alternative, and in the alternative it was directed that the state respondent should sanction new posts as SSA teachers by creating such cadre, which was also not done by the respondents concerned. And as far as the framing of a scheme is concerned, the direction was only given as a liberty to the state government to frame a scheme for giving further terms and conditions for regularization. Full stop. He, however, submits that the case placed by the government advocate was not in terms of the said order. Full stop para. On consideration of the submissions made by the learned counsels for all the parties, this court finds different. As has been stated above, the specific consideration of this court by order dated 17/3/2023 was to the effect that petitioners, that members of the Petitioner Association who were working as teachers under Samagra Siksha Abhijan, how did I start? Services, right? Should be regularized against the existing vacant post. No, should be considered for regularization. Should be considered for regularization against existing vacant post of government teachers in appropriate grade, in tune with the object of the Right to Education Act. And it is only in the alternative that this court had held that government had held and directed the government to sanction new posts as SSA teachers by creating the respective cadre. Full stop. The additional direction given by this court was to frame a scheme for regularization of the teachers if the state governments finds it fit. And with the further direction, and it was further directed that the exercise should be completed within a period of 6 months. However, it is seen that the state government had not followed the directions within the time frame, and after a period of more than 1 year from the date of passing of the judgment had published a scheme formulated by them, that is the scheme of 2024. A scheme ka naam likh dena na. Wait, I'm giving it to you. That is the Government of Mizoram regularization of centrally sponsored scheme, within bracket CSS, employees scheme to 2024. Full stop. The name itself, the name of the schemes itself suggests that the same is applicable to all the employees working under the centrally sponsored scheme, and it is not specifically meant for the petitioners. Whereas the directions were given in respect of the petitioners by this court. The contention of the learned counsel for the petitioner that the said scheme will also include the teachers, that is the employees of the association who had approached this writ court, will also not suffice the requirement in the order dated 17/3/2023. The various other exercises conducted after the scheme has been framed and published is also not in response to the direction given by this court. The said exercises were conducted for all the employees under the centrally sponsored scheme, and the gamut of the entire exercise is seen to be too large in respect of, it seems to be too large, since there are 6,000 employees, as it has been stated, under the said scheme. Further, the framing of the scheme was only given as a liberty to the state respondents. The main directions was to regularize the petitioners. The further prayer of the learned counsel for the state respondents that they need more time to comply with the directions of this order is bizarre in view of the fact that nothing has been, this will have no effect on the contempt case, I'll say, that nothing has been, in view of the fact that no concrete steps were taken as far as the petitioners are concerned, as has been ordered by this court. And now, almost 6 years have elapsed. Oh, 3 years, right? 24, 25. Almost 3 years have elapsed from the date of the judgment.
More than 3 years.
More than 3 years? Okay,
So
March.
March.
Not almost, huh? More than 3 years have elapsed from the date of the judgment. And it is in the considered opinion of this court that there can be no question of extending, giving extension of time to comply with the said order. As such, this I stands dismissed. However, the observations made in this order will have no effect on the consideration of the main contempt application. Okay? Okay. Then the contempt application, as prayed for by the learned counsels for all the parties, list this matter after 3 weeks.
My lord, they have already filed the respective affidavit. I have filed my reply.
Also, okay,
And now they are taking active steps to fill up the existing vacant posts by way of open advertisement.
Okay, list this matter on 13th of August. Will it do, Miss Mary?
Yes, Your Lordship.
13th of August.
Your Lordship, I have just one request, Your Lordship. With regards to item number 6, this matter was passed over. Your Lordship, I have a bereavement.
Okay, that matter is over, right? Contempt will come in
Yes,
14th of August.
My lord, can we have it on 7th of August?
Your Lordship, 13th of August.
7th of August. Please do some
13th is a
complete otherwise.
Thursday. Okay, 13th of August.
Okay, 13th of August.
7th of August, I'm proposing, my lord.
Okay, agree on a date.
7th of August.
13th, Your Lordship.
Because pleading
Well, I'll fix the middle
Your
date.
Lordship, he
Okay.
have a favorable order.
11th
in
of
his-
August. 11th of August.
Okay.
A mid date. Okay.
Your Lordship, I have a bereavement in the family. I have to go. So,
Okay.
if this matter is called item number 6, just.
Achha, 6, there was a prayer in the morning, right?
Yes.
And you were also on legs,
Yes.
and she was also on legs.
Yes.
So, okay, she has something to attend.
Yes.
So, when will we fix it?
Not may have it in second or third week. They can file a reply to the petition.
2nd or 3rd week of August?
I
So,
travel
okay.
from Delhi, my lord. So if it is
Okay, so you decide on a date. We are all here. When can you
21st,
come?
28th, my lord, any day.
2/8.
Sorry.
As prayed for by the learned counsel
Lord,
for
can
all.
it be either 10th of August or 7th of September, any day. Lord, I'll file a rejoinder because they will file a reply.
Okay.
I will have to, so I may have it on 7th of September, my lord, then.
7th of September.
Lord, they will take some time to file a reply.
Okay.
I will have to file a short rejoinder. to
Okay.
it.
Heard Miss Mary L. Kyangte, no, you are the petitioner, right?
Yes, ma'am.
Heard Mr.
Jatin Sehgal.
Mr. Jatin Sehgal, learned counsel, senior counsel, learned counsel appearing for the petitioner, and Miss Mary L. Kyangte, learned APP for the state.
Your Lordship, for the state respondent number 2.
This is criminal petition.
Yes.
For state respondent number 2. Learned counsel for Miss Mary L. Kyangte submits that she has she has bereavement in her family and she has to attend, and as such has prayed for some time. Prayer is allowed. List this matter on 10th of 7th of
7th of September.
7th of September
file a reply.
2026 for further consideration, and it is further directed that in the meantime the parties will exchange affidavits if any. List this matter accordingly. Interim order passed earlier shall continue until the next returnable date.
So grateful.
It's okay. Yes. What else? Acha, it's one. Rest of the matters at 2. Okay. Anything left? Some Passover. 1. No, there are matters in here also. Okay. Okay, rest of the matters at 2 then. Anybody has to say something?
Lordship, mine is item number 14.
14?
Yes.
So
Step has been taken.
Huh.
Dusty service has been taken. So I hope the matter can be taken.
You want to go? I'll pass the order at 2. Or you want to leave the court? Okay, give me the file of 14. Nothing much requires to be done here. Same
Lordship,
party, it seems.
I'm for the respondent
You were
number
for
1
the
and 2.
respondent in the other matter also.
Yes.
Yeah, here what is to be done?
Dusty
Respondent number 3 is served by way of Dusty. You are 3.
I'm 1 and 2.
So 3 no
He
representation.
has no. It appears that he has no interest in the matter because his name was initially in the case. His name was struck off, and then impleadment was applied for by the appellants. Now the service has been completed, and he has not appeared till date. So, Lordship, I am the claimant.
It's
and
okay. Case will proceed with in his presence. Okay.
in his absence.
In your presence.
In my presence, yes.
And 3, let it be not there. Let her be not there. So what has to be done today? You want to do or what? Paper book is prepared.
Paper book has been yes.
Given to you.
Yes.
So?
If the matter may be listed for hearing, Your Lordship.
Is it? Or it can be done today? No.
No. Next quarter. Yeah.
Okay. Learned counsel for the union of the insurance company.
Yes.
Insurance company, Mr. So and so submits that the paper book is ready And the service is also complete upon respondent number 1 and 2.
And 3 also.
He, full stop, he further submits that notice is also complete upon respondent number 3, but there is no representation. And the learned counsel for respondent number 1 and 2, Mr. So-and-so, submits that respondent number 3 has no interest in the matter, and the matter be proceeded in the absence of the said respondent. However, there are the prayers are made by both the parties to take this matter up for hearing, to take up this matter for hearing on a subsequent date. Prayer is allowed. Place this matter on 28th of August, Thursday, for hearing.
Yes.
28th of August, Thursday, for hearing.
Obliged.
Ouch. Wait. Okay. It's Mr. Subedi, right? Yes.
Item number 15.
Item number
15.
15. You are there?
Yes, yes.
Okay.
The respondent numbers 1 has entered into appearance and they have submitted their wakalat number already. And
So
regarding
respondent number 1 has appeared.
represented, they have submitted their power. Though they are not present today, it has been reflected already. And then 2 and 3, we could not find out these people, though we were directed to do dusty service. So I may be allowed to ascertain the proper address of those respondent number 2 and 3 and take fresh steps against them by way of telephone. I'll try to obtain the correct address from the claimant's counsel. I believe that they will help me out in that. So I'll take steps against those two.
Okay.
respondents.
Again, fresh steps.
Fresh steps.
The dusty that was allowed,
Yes.
a notice by way of dusty requisite. You have already taken steps to dusty.
Yes, we have taken steps, but we could not find out the respondent 2 and 3 in their address. So
You have not filed your affidavit. Okay,
yes,
but then.
not filed affidavit.
Okay. This is what? MSc?
Yes.
I is for?
Delay of 58
Delay.
days.
Okay. Okay, heard Mr. R. Subedi, learned,
I'm for the applicant.
learned counsel for the, some Pradeep Chetri has entered
They are
appearance.
for the respondent 1.
But today he is not there.
Yeah,
Not
they
even online.
Yes.
Heard Mr. R. Subedi, learned counsel for the applicant. This is IA, right? Applicant. Mr. Subedi submits that respondent number 1 has entered appearance through an advocate. However, he is not present today. He further submits that in respect of respondent number 2 and 3, he prays that he will collect the correct address of the said respondents and would take fresh steps by way of dusty for service of notice upon them. Prayer is allowed. The petitioner is, yes, prayer is allowed. The learned counsel appearing for petitioner may take out the proper address of the said respondents and would take fresh steps by way of dusty and would file an affidavit showing the service thereof on the next date. List this matter when then?
3 weeks time.
List this matter on 21st of August 2026.
I'm obliged.
Item number 16.
My lord, in
Yes.
this matter also, respondent number 1 is represented and 2 is still awaited.
Respondent number 1 also no appearance today. And
Yes.
2 is awaited.
Yes.
2, oh, okay. This has gone by speed post only, no? By
Yes.
filing Talabana.
Yes. My lord, will it be possible to check the consignment
When was it taken?
on March?
March to 3 months have
Oh.
already gone. April, May, June.
Yes, yes. In that case, we will take fresh step, my lord.
By taking on the proper address or what?
Yes.
Address is okay?
I have his phone number in the
Huh.
trial court.
Okay, heard Mr.
H. Jodin Sanga.
H. Joding Sanga, learned counsel for the applicant.
Okay.
It is seen that the service of notice upon respondent number 1 is complete. And on the last occasion, the learned counsels have appeared on behalf of the said respondent. Or no? No. It's
no
complete. And is complete, and learned counsels have filed their wakalatnama for the said respondent. However, it is seen that the service of notice is not complete upon respondent number 2. The learned counsel appearing for the applicant submits that he be allowed to take fresh steps for service of notice upon the said respondent. Prayer is allowed. The petitioner is directed to take fresh steps for service of notice upon respondent number 2 by taking out the proper address. List this matter on 21st of August.
Yes, my lord. And my lord, the answer that petition may be allowed to use again for taking steps if it is in the record, in the registry.
You take fresh steps, why again?
No, I mean that petition application.
Answer which is not stated here.
Or if it is there, my lord.
No, has returned while service report AD has not returned. No, one is returned. AD card has not returned. Neither unserved. Nothing is written.
Yes, my lord. Sometimes when it is unserved, they didn't allow to use the copy again for serving again.
Achha.
That-
It is further directed that if the unserved copy has been received back by the registry,
Yes, my lord.
the same can be used for taking the further fresh steps by the applicant. List this matter on 21st of August.
Item 17.
Bail application.
Yes, Your Lordship. May it pleases Your Lordship. 483 bail application, and it is alleged by the prosecution that some.
Case diary has come.
No, Your Lordship.
But today is the first day.
Yes, Your Lordship.
Case diary will be required.
Yes, Your Lordship.
This is what, NDPS?
NDPS, Your Lordship.
Okay, let the case diary be called. Heard Mr.
A. Ghoshal on behalf of.
A. Ghoshal on behalf of Mr. M. Biswas, learned counsel for the petitioner, and Ms. Veni Sharmi, learned APP for the state. By this application filed under section 483
Yes, sir.
of BNSS 2023, the petitioner has prayed for bail in connection with Saitual PS case number 54 of 2026,
Yes.
registered under section 21CB, small c within bracket, small b within bracket, /25/29 of the NDPS Act 1985. Call for the case diary in connection with the aforesaid case. Charge sheeted.
No, Your Lordship.
Okay, call for the case diary in connection with the aforesaid case. List this matter.
3rd of
on-
August, Your Lordship.
On
3rd of August.
3rd of August.
My Lord, it will be petitioners, Your Lordship. There are two.
Oh, there are two. Okay, petitioners. Huh?
Obliged, Your Lordship.
Item 18.
I in contempt case again for extension or what? No, no.
Lord, the IA was for implement of the new incumbent.
Oh, implement.
Yes, my lord. And my lord, in the main petition, my lord, the petitioner and the private company who had undertaken the construction of the road had entered into a settlement. So eventually they have come to terms, and the matter can be closed at this stage.
The main contempt case.
In the main contempt,
So implement is not required now.
it's not required.
So what had happened? What is the what? Who has entered into an agreement?
The petitioner and the respondent.
You are for
For the petitioner.
petitioner.
Yes, my lord.
You have entered into an
I have
agreement
a copy
with.
of the agreement, my lord.
Uh-huh.
I have a copy of the agreement.
Acha. Okay, just show me then. But first of all, what is the order that has been not complied?
My lord, the order is that the respondents will will assess the damage, and if they intend to acquire, then compensation should be paid. If not, the damage has to be paid, and the land will not be utilized further. And in that, my lord, they have come to a settlement of 6 lakhs for damage. They have paid 6 lakhs for damage, and
So come to a settlement. So the who used to fix the district collector used to, or settlement officer who used to fix the quantum of money?
my lord, this actually is not bound by the
Acha.
by the Railways Act or anything else.
Acha, show me that order of the Scott.
It's in the main petition, my lord.
Okay, by Justice Silo.
Yes.
Page number 10.
An extra one. Yes.
Okay. Okay. Where is the operative portion?
Page 10. Yes, my lord.
12. Secretary to the Land Revenue shall consider verification team or his representative, the deputy chief or his representative, verify the land of the same order type. Huh? They will first verify the land, and verification team shall verify whether the land of the has been used by respondent 4 and 5 for construction of a road. There is within 2 months on date of the verification taken decision as to whether they want to permanently acquire. There shall be requisition. Thereafter, an award shall be made. If they do not, then stop using. In that event, shall verify the SS so and so. Okay. So you are the owner of the land?
Yes.
And what is the land that has been damaged? A verification team has been constituted?
It has been constituted, my lord.
They have verified?
They have verified, and the private contractor has paid the amount to the petition.
Contractor of which department? Private contractor means for construction of road, PWD? No.
No. It's the private contractors had constructed a road within the
Private
petitioner's-
contractor for whom?
For the
PWD?
railways. For the railways.
Railways?
Yes.
Okay. Now, where is the document to show that verification team and all were constituted? Nothing.
Due to the non-compliance of the order, the contempt petition has.
So nothing was done after
nothing
this
was
order?
done after that, my lord.
Then where is the settlement now?
My lord, it's in my bag. I'll just get.
Sure. Bring it. You are for the railways contractor?
Your Lordship, for the Deputy Commissioner.
For the Deputy Commissioner?
Yes, Your Lordship. On behalf of my senior.
Miss Mary?
Yes, Your Lordship.
She had to go. Okay, just give me that settlement order. Hey, be careful. Ming Thang Fella. Who is NCDAS?
CDAS are the private contractors, my lord, under the railway.
That money was already given.
Given.
No, he said that the first party said he will not claim, he will not have any claim over the scheduled land. So that means he had given the land to the railways. And then railways said that they will not use it.
No, my lord.
See the terms number 3 of the settlement.
There was an amendment to this, my lord. Even, in fact, I was quite.
But okay, what do you say? This is not there. The second party will vacate the first party's land. What do you say? You're for the contractor, you're for the district collector, right?
Yes, Your Lordship.
What do you say on this, in this matter?
Lordship, I have no instructions regarding that. I will have to ask my senior.
My lord, it's agreeable, my lord. Now that I have perused, my lord, it's agreeable to the petitioner.
It is?
Yes, my lord. Because the first party will not make any further claim. That is the intent, my lord. Not regarding the ownership. So and.
But then he said that he will not have any claim over the scheduled land. Second party will vacate the first party's land that they are currently
in terms
used.
of compensation. This is in terms of compensation. So the second party will vacate the first party's land and will no longer use again. So in that case, my lord, both the parties have consented, man.
So on this basis, we can dispose it of.
Yes, my lord.
Since you are the petitioner and you are claiming the compensation, and if you are satisfied, so what is the requirement of the other parties, right? Otherwise, he is only for district collector, he doesn't have the information.
Correct. Correct.
And who else are parties to this contempt petition? We have made so many.
Yes, from my lord, the deputy engineer, Mr. Meena was impleted lastly, and the project managers.
Heard Mr. Jonathan Lal Rakunga Pautu, learned counsel for the in the contempt case, you write, huh? Petitioner petitioner for the petitioner, learned counsel appearing for the petitioner, and Mr.
Daniel Shassel on behalf
learned counsel appearing for respondent number 3.
Your Lordship.
3. Respondent number 3. Mr. Pautu, learned counsel for the. Oh no, wait. This is a contempt application filed by the petitioner alleging non-compliance of the judgment and order dated dated 5/8/2022, passed in WPC number 29 of 2021. Full stop. By the said order, this court had directed the Secretary to the Government of Mizoram, Land Revenue and Settlement Department, to constitute a verification team consisting of the Deputy Commissioner, cum District Collector, Kolasip, or his representative, comma, the Deputy Chief Engineer, Construction, NF Railways, comma, Silchar Kachar, or his representative, and a petitioner. Who is directed to verify the land of the petitioner within a time frame. Full stop. It was further directed that the verification team should verify as to whether the land of the petitioner has been used by the railways for construction of a road. Respondent number 4 and 5 are the railways. Where the railways? We cannot know, right? Now, used by the respondents for construction of a road. And if it is found by the verification team that it has been used as such, the respondent number 4 was directed to decide as to whether they want to permanently acquire the land of the petitioner. And if it is found that the respondent is required to acquire the land, then necessary exercise should be taken under the Land Acquisition Act, and the compensation should be paid to the landowner within a time frame. It was further directed by this court that if respondent number 4 decides not to acquire the land of the petitioner, in that case, he will. In that case, respondent number 3 should verify. Who is respondent number 3? I think the district collector.
Yes,
Respondent number 3, that is the district collector, to verify and assess the damage caused to the said land and pay the damage and assess the damage. What did I say? Respondent number 3, that is the district collector. The petitioner's land and the said assessment to be forwarded to respondent number 4, who would pay the amount within a time frame to the petitioner. Full stop, para. However, full stop, para. The said directions were intimated by the petitioner on, I've given the date of the order, right? 5/8, right? I have given. Yes, intimated said directions to the respondent authorities via a letter dated 9th of June 2022. However, the learned counsel for the petitioner submits that nothing was done after that and the order was not complied with. Well, verification was done. You see, you have yourself
Verification was done.
verification report. The learned counsel for the cut that, huh? The learned counsel for the petitioner submits that pursuant to the said order, verification was conducted and it was found that the railways have constructed the road over the land of the petitioner. But however, he submits that the rest of the directions contained in the said order dated 5/8/2022 was not complied with by the authorities. The learned counsel further submits that during pendency of the instant contempt petition, a settlement was entered into between the petitioner and
The respondent number 7.
respondent number 7. Who is the project director? Project director means he was constructing the land. He was constructing the rail. What? He was
Yes.
using the land.
He was using the land, yes, correct.
No, railways were using the land to carry articles.
My lord, no, he was the one who had undertaken the construction.
Acha. Project director who had undertaken the construction work for the railways. And in the said agreement, it was agreed that the petitioner agreed that the said respondent would pay rupees 6 lakhs to the petitioner as compensation for utilizing the land of the petitioner as a route for transporting materials for construction of railway track. Full stop. It was further settled amongst the parties. It was further stated in the said settlement. That the said amount of rupees 6 lakhs was already paid to the petitioner, and that the petitioner does not have any claim pending with the respondents. It was also stated that the respondent authority will vacate the petitioner's land, and that the same will not be used for the said purpose. The said settlement is signed by both the parties, that is the petitioner and the representative of respondent number 7. Representative of respondent number 7. Respondent number 7 is Zakir Hussain. Project manager is NC Das and company. NC Das company, right? Okay.
Tushar Dekra, the signatory in the agreement was actually respondent number 5.
Respondent
number 5. He was also the project.
Yes, the representative of the respondent number 7. A representative of the NC Das and company is where? Is he made a party? No.
Made a party.
No. These are all representatives. Achha, representatives of the company. Representative of the company who was who was using the road. Who was using the petitioner's land as a road for carrying the railway materials. In view of the said settlement, the learned counsel for the petitioner submits that the in view of the settlement and in view of the specific statement made by the petitioner that compensation for the damage caused to his land has been accepted by the petitioner, this court finds it fit that the instant contempt application be closed for the ends of justice. Petition is as such disposed of and closed, right? In the IA, you write, in view of the order passed in the contempt application, the instant IA stands closed. Okay?
Part 2, hearing list, item 27.
27, no one is there. Court is empty. 27, who appears? Lal Pakama. This is MSc appeal. None appears on call for the parties. However, the matter be again listed on 6th of August for consideration. Yes. Any more? Nothing. Okay. Okay.